Welcome to Agent Talks with the Authors Guild Foundation in collaboration with the Association of American Literary Agents, AALA, formerly known as AAR years ago, and Literary Agents of Change. Our guests can talk about those organizations in a moment. But in this series, we bring on a guest speaker, a literary agent, to speak to an area of their expertise, give us some advice that's in their wheelhouse, and learn about some things from the agent's perspective. And today it's book contract basics, a favorite topic here at the Authors Guild. We'll have some time for Q&A at the end, so feel free to pop questions in the Q&A box here in Zoom. But we have a lot of questions already, and our guest, Rebecca Matt, has a wonderful presentation planned, so we'll get to that first. I just want to say quickly, in case you don't know, the Authors Guild offers contract reviews and other legal advice related to writing and publishing. You can, we'll be posting links to some of our resources in the chat, but feel free to email staff@authorsguild.org if you have any questions about what we do, or just check out membership info on our site. I'll say quickly, I'm joined by our Director of Legal Services, Michael Gross. He's just here to help answer any questions if needed. But I'll introduce now our guest of honor, Rebecca Matt, literary agent and contracts manager at Bradford Literary Agency. Prior to Bradford, she worked as assistant to executive agent Laura Renner at the Andrea Brown Literary Agency, where she provided editorial and contract support for a wide array of books across genre and age range. She began her professional life as an IP and contracts lawyer for several prominent law firms in New York City. Rebecca, thank you so much for being here. Thank you so much for having this presentation for us. And moderating the conversation will be Tamara Kawar, literary agent at DeFiore Company. Tamara, I'll turn it over to you.
Thanks, Johnny. Hi, everyone. Thank you so much for joining us on this Monday evening. As Johnny mentioned, the Agent Talk series is hosted by the Authors Guild Foundation in partnership with the Association of American Literary Agents, AALA, and Literary Agents of Change, LAOC. I'm Tamara, literary agent at DeFiore Company, and I'll be your moderator today. I'm a member of the AALA and a co-director of Literary Agents of Change's mentorship program. A little bit about our mentorship program. It was founded to serve people from historically underrepresented groups in the agenting community and seeks to increase retention and promotion of literary agents. In addition to the mentorship program, Literary Agents of Change's most recent initiative, which went live last week, actually, is the Equity Directory, an online database of BIPOC literary agents to help queering authors and illustrators connect with BIPOC agents and to foster community between BIPOC agents and their publishing peers. Johnny, if you could drop a link to our website, and I can also drop a link to the directory in the chat so you can learn more about us and about the directory. So we're very excited about the success of the Agent Talk series so far, and very excited to see such a great turnout for a member of our mentorship cohort, Rebecca Matt, who is leading this webinar on contracts. As Johnny said, if you have any questions, drop them in the Q&A. I've also prepared some pre-submitted questions that we'll address at the end of the presentation. So without further ado, Rebecca, take it away.
Hi, everyone. I am thrilled to be here. I'm Rebecca Maddie. My name is a trick, so don't worry about it, but Maddie. And I am excited to share my knowledge of contracts. My goal with all of this, I know Authors Guild has amazing resources already, but just to give everyone sort of a working knowledge of how to read a contract and what to expect once you get one. I do have a presentation, so I'm going to share my screen to do that, and we can get started. So in creating this presentation, which I should absolutely full screen, I basically took an existing contract that I found online. I'm going to make this full screen and then figure out how to do that. And I broke it down into sections. So these are not representative of good contract provisions necessarily. I would use the Authors Guild resources in that case rather than these, but these are just meant to demonstrate and help make things clear. All right, that's much better full screen. So in this presentation, we're going to talk about the structure of a contract. In general, and they all vary, but in general, they follow the same basic structure. The first bit are whereas clauses and introductions. The next are material terms. Usually, but not always, especially for publishing contracts, the most important terms are up top. Following that are some other terms that I really wanted to go through specifically, like termination, representations and warranties and indemnities, which are probably, in my opinion, the most important piece of the contract to understand that is not clear from its language. So we'll get to that later. And then some miscellaneous things to look out for. Starting with the whereas clauses, this is a lot of legalese that can sound very dense, but really it is a very basic statement of the parties, the date, and the subject. So basically, you review them to make sure that you understand who is involved here and what is involved here. So, for example, this agreement is entered into as of the date between this party and that party, usually one of them is you, concerning the title of your book. The title and description is something that you want to make sure that you take a look at to make sure that when the publisher has written it down, they have the basic either concept, genre, age range, or word count properly there, as well as a tricky thing that happens in some of these contracts is looking at parties and how they are defined. So sometimes it will say the company being, I'm picking this out of a hat, so do not take this as anything negative about them, but like Penguin Random House and their partners, subsidiaries, affiliates, and so on, right? That usually just means Penguin Random House, but it's good to look at that to see, like, so you know who you are entering into the agreement with. From there, we get into material terms. For a book contract or a short story contract, the most important things for you are copyright and grant of rights. That means the amount of material that you are giving permission for the publisher or magazine or anyone to use. Under copyright law, there are some basic rights. Those rights are to reproduce, meaning make copies, make derivative works, which can be anything from audio to ebooks to plays to a game or something like that. Distribute, which is its own right actually, perform, and sound recordings. That's usually for music, but could apply to audio recordings as well. It is important to know what you're giving them, for how long, and where. So in the context of book contracts, you're going to look at like world English, world all languages, North American English, North American all languages. That tells you where this can happen and in what languages. Like, are you giving foreign rights? So a really, really expansive grant of rights is world all languages. A more narrow one is North American English. Or if you're doing foreign rights, like, Russian, that could be the area. You can distribute in Russia and produce in the Russian language. And then there are things like subsidiary rights. These are the derivative works, typically audio, serial, meaning like in smaller chunks, translation for foreign languages, merchandise, foreign English rights like UK and book club, and so on and so forth. These are all things that are going to be in their own section of the agreement. So looking at one of these sections, the different colors mean nothing. It's just to sort of identify what you're looking at. There's a lot of language here, right? The first piece of this, the author, on behalf of himself and his heirs, executors, administrators, successors, assigns, that all just means you, right? That means you, the author. Exclusively, meaning just them, grants, assigns, otherwise transfers. That all means the same thing in this context. To the publisher, its licensees, successors, assigns, all right and title and interest in the work. Again, all that says is you, the author, are giving the publisher the right to, and then the part highlighted in yellow is the thing that you need to look at to understand, because it says throughout the world, in all media, and for the full term of copyright. That's the most important things for you to know, right? And then it says in the blue, print, electronic, digital, audio, video, those are the forms. For the most part, these are the things to look at. Don't get bogged down in the list, is kind of, I guess, the takeaway from this. Next, we're going to look at what else is the publisher promising other than paying you, because obviously paying you is very important. the publisher should be making some promises, right? Like you're not going to get everything that you want necessarily, but you are delivering the book. What else are they promising you? Some things might be a timeline for publication. Usually it's within 24 months of receiving the, the final copy, or within 12 months, or within 36 months, whatever they're willing to promise. Any advertising or promotion specifics, though, I'll be very honest, you're very unlikely to get those in most modern publishing agreements, but if you can, great. And author copies, you get free copies. Your agent gets copies. So make sure that you know what you're giving and getting. Next, this is for short stories, but also is relevant to books as well. Can you publish the piece elsewhere? I just negotiated a contract for a anthology of short stories, for example, that had a exclusive time period for, I believe, 18 months after publication. But after that, all of the short story writers were allowed to submit the piece elsewhere or to publish it elsewhere. So that is a temporary exclusive submission, and then non-exclusive. And if it's non-exclusive, and in almost every case, unless you're doing what's called IP work or work for hire, you always make sure you retain the copyright. Very important. Next, you have competing works. This is what other things can you do that are similar to this book, right? So in most publishing contracts, you're going to see that you can't publish a similar book within X period of publication. Now, similar is the thing that you will hopefully get your agent, or that you will be able to negotiate to be as narrow as possible. So instead of saying a book that's similar, because what does that even mean, even though it's usually the beginning place, you'll get something along the lines of the next, or a book that is adult fantasy featuring academia. That's incredibly narrow. More likely you're going to land somewhere in the middle. But it's important to know, what are you allowed to write while this contract exists, and when are those restrictions in place? The next is the right of first publication, which is more for short stories, or in book publishing, it's more a next works clause. Does the publisher require that they're the first one to have done it, which is usually temporary exclusivity? Or in terms of a book, does this have to be the next book that you publish, or can you publish something in the meantime? If you have something else in the meantime, that's something that has to go in the contract. And finally, what medium are they allowed to use? This again is more useful for short stories, but digital, print, and audio are all different rights. So make sure you know that if you're conveying rights, exactly what those rights are, and make sure that you are paid for each type of rights that you convey for a short story. Next up is the publisher's right to edit. And there's a lot of clauses that usually give the publisher the right to edit and revise the work, which is fair, right? Like they're your editor. That's something that they should and often do engage in, are these edits. But it's important that you're the author, right? You're the person who wrote this book. You retain the copyright. And so what you want to look at these is, can they make material changes, material meaning substantive in this case, without your approval? Or is it kind of just spelling and grammar kind of deal? For books that are very specific to a culture or religion, for example, there may be grammatical changes that you don't want made, even if they're considered quote unquote standard. This is something that I see a lot in picture books, for example, where a rhyme scheme needs to be preserved. So even though something may not be grammatically correct, you want to make sure that you retain the right to approve any edits to the rhyme scheme. Or if you're writing a book, I'm going to use my own experience here. If you're writing a book about the holiday of Purim, which is a Jewish holiday that's coming up, then you need to make sure that the language that's used around that, the spellings and all of that, are correct, right? So what editing is the publisher allowed to do? Sometimes even proofreading, quote unquote, can be something that you want to make sure that you understand. And what happens if you disapprove of a change that they want to make? It could mean that the end of the agreement happens, but it doesn't have to. Next, probably the most, I keep saying the most important thing, probably the thing that is the most salient to authors is payment. How much are you being paid and on what schedule, right? you need to know when you can expect money. This is a short story agreement that I have here, but it says the publisher shall pay to the author as an advance against royalties, a sum of $300 to be paid as follows, and then it provides a schedule. This may or may not be something that is a good term depending on what the agreement is for, but it does tell you all of the information you need to know, right? If there are no timelines, then there's nothing to hold the publisher to. And that's very important. The contract is both giving you assurances and protections. You also need to know, are there any prerequisites to payment, right? Is it that you need to deliver the whole work and it needs to be approved? A lot of times in book publishing, for example, you'll see a clause that says you need to have the lawyer review it, the internal lawyer, and if they don't approve of anything, the book's not accepted, right? So those are important things to know, or what are the prerequisites and contingencies there? And what do you have, what rights do you have if you aren't paid? A lot of times, the only right you have is to terminate the contract, but you need to have the right to terminate the contract. Otherwise, they keep your rights and you're not getting paid. That's not very helpful. And similarly, it's important to know that you do have other legal remedies, right? This is something that you can do by just suing. Now, obviously, suing is not the goal here, but it is important to know that you do have that right so long as you don't waive it. All right, next we have, after our material terms, term and termination. These sort of go hand in hand, even though they're going to be in different sections of the agreement. The term of a publishing agreement is usually the full life of copyright, which is like your life of the author, plus 70 years, or it's for a very specific defined period. I've seen like 7 years, for example, is a commonly used term for these. Next, you have termination, though, because even if something is granted for the full life of copyright, it can still be terminated early. So you need to know what triggers it. Are you allowed to do it, or does it have to be done by the publisher? In my contract negotiations, I always try to make sure that there is a way for the author to do it. For example, if the book is out of print, that might be a way that you're like, okay, you're not doing a good job anymore selling these rights, selling these books. I think I could do it better. I want to terminate this agreement, get my rights back. They might not say yes, but most contracts these days involve out of print provisions. But similarly, the publisher has the same right. And usually there's a right to terminate if one of you does something wrong under the terms of the agreement. And then you have to know, is there, if it's a short period, like a 7-year agreement, is there a right to renew, right? Does it automatically happen? There are a lot of agreements that say for an initial term and then automatically renewing on a yearly basis unless X happens. X might be someone chooses not to renew it, or it might be a letter is sent exactly 60 days before the end of the term on a full moon and by registered mail. Now, the full moon part is not real, but the rest of it is, because it can be very specific. So you just need to know exactly what that means. And when it terminates, that implicates both your payment and rights reversion. Reversion meaning you get all of the rights back that you conveyed. So you have to know, A, when are you getting them back? B, do you have to pay anything back? Because sometimes, like if it terminates before a book is on sale, you may have to repay in advance. Ideally not, but it is involved in most contracts these days. And do you keep getting royalties, right? Make sure that if royalties are earned after the termination date, you keep getting paid. Those are your books, those are your royalties. You should be paid. So looking at a contract provision, oops, sorry. I have fully lost track of things. Okay. Publisher's rights on delivery. If the publisher deems the manuscript and any other materials unacceptable, the publisher can advise the author. And if it's not fixed within 30 days, the publisher has the right to terminate the agreement without further obligation to the author. So this is one of the ways that this agreement, for example, could be terminated. Now, again, don't get bogged down in the synonyms: fully revised, corrected, and or supplemented, manuscript, artwork, front matter, and or back matter, right? There's a lot of synonyms here. There's a lot of and ors, including but not limited tos. On your first read, you can skip through those to understand what it's saying. Later, you should go back and read them to make sure you know what's involved, but don't let the legalese of it bog you down. Usually it's simpler than it appears. All right, next, termination for non-delivery. This, if you fail to deliver, the author shall immediately repay the publisher sums previously paid. So that means any advance, if you don't deliver the manuscript under this agreement, the publisher has the right to terminate and you have to repay the advance. That's because you never gave them a book. That seems relatively fair to me, but some of them are more and less fair. And then there's just the publisher's right to terminate. The publisher has the right to terminate if the author does not fulfill the obligations, but the author is given a 9-month grace period. There's going to be a lot of different ways to terminate this agreement. They're all going to be scattered throughout. Remember, this was paragraph 9, paragraph 10, paragraph 30. So this is something that is not all going to be in one place that you just keep an eye out for. Make sure you know what happens if you do something and under what circumstances you have to give money back, because the general rule is money should always go to you, not away from you. You also, under this agreement, have the right to terminate if the author is not satisfied in your sole judgment with any aspect of the relationship. That's really broad. That's not usually the way that it works. But it says to exercise this right, you must send a written notification. The publisher then gets to respond. Then you can give them a written notice. And this is the kind of thing where I say there's a lot of jumps to, hoops to jump through. Not necessarily bad or a red flag, but useful to know because it means that you have to start this process several months, probably 6 months before the termination will actually even happen. Next, reversion. This, when termination happens, is incredibly important. You need to know when you sign a contract, when do you get your rights back? Can you get them back earlier and how? And can the publisher assign them to someone else? Usually, rights revert back to you when the contract is terminated, right? However, you might be able to get them back earlier. There are, for example, ways to negotiate rights reversions for sub-rights like audio and foreign rights, where you say, well, we didn't really want to give these to you in the first place, but you insisted. We want them back after 3 years if you haven't done something with them. That's usually will be separate language in a contract and can be negotiated by you or your agent. And it's a way, for example, if foreign rights are really important to you, to make sure that they do something with them. And if they don't, you get to. That's one way to get them back earlier. So in this, upon termination, according to any of those provisions, all rights in the work granted to the publisher, except the right to dispose of existing stock, meaning they can sell their own books, will revert back to the author. That is the kind of reversion that you are looking to see. In any termination provision, there has to be language that states how you get your rights back. The only time you do not get your rights back is if you basically do what's called a work for hire, or what we in the publishing industry call an IP agreement, right? Doing something where you are doing it at the request of the publisher and it's going to be their IP, their intellectual property to work with. This is a smaller percentage of agreements, but does exist. All right. This, in my opinion, is the thing that is the least well understood, and as a lawyer, the most important thing for me to confirm with clients when I am helping to advise them. Reps and warranties are promises that you are making to the publisher. It's going to be a long list. It's going to say the author will represent to the following. And I'm going to just actually jump to the next slide. It's going to be a very dense paragraph with a lot of very specific legalese. This is a very standard rep and warranty paragraph. The work is not in the public domain. You're the only author of this book, and you have the right to enter into it. The book has not yet been published. The book does not, if it is published, infringe on anybody's rights. All of the statements are true. all instructions are safe and you're not going to kill anyone by following them. If it's biographical, it's authentic and accurate. This is all relatively simple to do when you are indeed the sole author of a new book that has not yet been published. But it is incredibly important that these promises are accurate. So I was actually just telling some of the Authors Guild team before this call started, I'm currently in a fight with a publisher about whether a book has been previously published, because it's a book that it was self-published. And so I am trying very hard to remove that representation, because you can't represent the book hasn't been published when it has been published. And publishers are very reluctant to change their reps and warranties. But if you cannot promise something in here, do not agree to that thing. And I will explain why in just a minute. But an important thing to do is to confirm who you are promising, right? You are usually promising publisher, but what does publisher mean, right? That's where we go back to that first paragraph, who the parties are, because usually publisher will be a defined term. And so you need to know who is allowed to hold you to these promises. Is it just the company known as, for example, Penguin Random House, or is it their customers? Because sometimes they extend to customers, which I think is weird, but it is relatively common. Why are these so important? Well, the other piece of this is indemnity. Indemnity is a promise to pay if somebody else sues the publisher as a result of a breach of your reps and warranties. So if you make a promise that this book has never before been published, or that you are the only author of the book, that's an easier one. But you're not. You actually had a joint author. You forgot about them, or you lied about them. That joint author can now sue the publisher saying, you've stolen my intellectual property, you violated my copyright. If that person sues, you have to pay all of the legal bills and all of the court costs and any amount of liability, right? If there's a judgment in favor of your co-author, you have to pay the publisher's share, because it was a promise that was in this agreement that you breached. And now, ideally, you're not going to do this. And I will tell you, in all of my years in publishing, I have never seen an indemnity actually be applied, but they are. And it's an important thing to be aware of, because that can be a lot of money. So it's a difficult thing to enforce. It's a difficult thing to negotiate, because again, publishers are very touchy about these. The places that I try and push and get negotiations on are, for example, attorney's fees, because it will say, if you see in the blue, it covers any liabilities, losses, expenses, including attorney's fees and costs. As an attorney, lawyers are expensive. Some lawyers are extraordinarily expensive. Including the term reasonable before attorney's fees limits it to what a court in that, like the place where that person works, has decided is reasonable. So like, for example, I happen to do special education law as well as this, so I can tell you a reasonable attorney fee for special education law for someone who's done it for 12 years is $500. It could be $500, $600, somewhere in that range. There are lawyers who charge $1,000. So without that term reasonable, you would have to pay the full $1,000 if it were a copyright lawyer. With the term reasonable, you're limited to the $500. Now, ideally, it never comes up, but it's a good way to protect yourself. Similarly, I try and push on what actually has to happen. Do you need proof that you lied, or can someone just claim that you lied? Because most indemnities, unfortunately, these days have the red language based on allegations, which, if true, would be a breach of the reps and warranties. Meaning, like, I know, look, I don't like this person anymore and I have issues with her beliefs, but as a good example, J.K. Rowling was sued over the term muggle. Muggle is a term that she believes she made up. Someone else claims that she didn't, that she stole it from them. Now, that person is wrong and was proven wrong in a court of law, but until she's proven wrong, that author still had to pay all of those fees probably. I don't actually know, I was not involved in the case, but that's the kind of thing here where anyone can claim it and you would have to pay. That's the kind of maybe some negotiating space, though I'll be honest, it is not successful most of the time against like the big five. So in reading it, it just says, you, the author, shall indemnify, defend, and hold harmless, which means you are paying for the publisher, its parent company, subsidiaries, affiliates, shareholders, officers, directors, employees, partners, associates, affiliates, joint ventures, agents, and representatives. That's a whole lot of people. Relatively reasonable list, unfortunately, but it means if the editor, for example, is sued, you're paying the fees. If the CEO is sued, same thing, right? So that's why you make very sure that those representations and warranties are things that you can agree to. And it should be relatively easy to know that. And once you do, then you should be good to go. All right, miscellaneous, but important. Approval for use of your name, face, and bio. Try and get the words pre-approved in there. So the publisher shall have the right to use the author's name, image, and likeness and biographical matter. See if you can get pre-approved or provided by author put in there. And that way, like I've heard stories, not from anybody that I know, but of publishers like doing research on people and putting information in that they may not have wanted in there. So it's an easy way to make sure that you get to look at it first. And if you don't want your face there, right? If it's a pen name, you may not want your face on the book. So you got to say pre-approved or provided by you. The terms joint and several liability. If you're working with a partner, what you do may impact them and vice versa. So joint liability means that you are liable to things, joint and several liability, sorry, means that you are responsible for everything that they do as much as they are responsible for them. So you just want to make sure that you know what happens if you are working with a partner, right? So you can share equally in the royalties and other amounts, and you're jointly and severally, meaning individually and together, responsible for all of the promises and obligations. So again, working with a partner, make sure that all their promises are right too, because you could be responsible for what they promise. Applicable law, what law governs the case? At the end of almost every contract, you will see, no matter where this contract was executed, I'm actually not even reading it, regardless of the place of its physical execution, the agreement shall be interpreted, construed, and governed by the laws of Pennsylvania. So basically that provision means we are not in Pennsylvania right now, but we're all going to pretend that we were in Pennsylvania when we signed it, because that's the law that we're going to follow. As a rule of thumb, it's usually where the publisher is based. New York is pretty good as a choice. California law is more complicated. It's usually not a big deal, but it's something to just keep an eye on. Same thing with venue. Venue means where you would have a lawsuit. If a problem arises and you have a lawsuit, where are you willing to travel, right? Because if you need to travel to England, that's a big deal, right? Exclusive international venue is a difficult thing, right? Because exclusive means only them. International is anywhere overseas, right? So if you're working with a UK publisher and they put in there that any court case would be held in Lancashire, you're going to Lancashire if a problem comes up. So just a thing to, be aware of. Also, publishers have insurance in almost every case. It's almost always worth asking if a publisher does, so that when you have an indemnification clause, it only covers the amount not covered under insurance. And this is something that almost every publisher will allow. Arbitration. There are a lot of clauses, like the one that's on the screen, that says if a dispute arises, first you have to mediate, and then you go to binding arbitration, which just means a person who's paid by the hour gets to decide your case for you, not a judge. It is legally binding. It will affect your ability to sue, and it waives your right to sue in court. This is not necessarily good or bad. It goes both ways, but it is an important thing to know. And if you have strong feelings about arbitration, see if you can get rid of that clause. I don't think it really bends one way or the other in my experience. Finally, Here are some tricks that you can use that I like to end this with, like, all right, so you're negotiating a contract, you're with a publisher who's not going to give you much wiggle room. What are some things you can do to move it in your favor, right? So there are some very basic turns of phrase that you can use to either soften or strengthen the obligations. So for example, a type of effort. There might be a clause saying, author will use their best efforts to attend every promotional event run by the publisher, right? Best efforts colloquially doesn't sound too bad, but actually on the range of what efforts are, best efforts is one of the strongest, right? So at the bottom, the lowest level of effort is reasonable, because that's like what any person on the street would do. Excuse me. The next is commercially reasonable, what any business would do. Following that is best efforts, or every effort, right? And that means as much as you can do without hurting yourself, basically, right? Your best effort. So if it's an obligation that you have, like attending promotional stops, try and make it reasonable efforts or commercially reasonable efforts, right? You can go to the places that cost you $100 to get to, but not $1,000 to get to, right? But if it's something that you're trying to get the publisher to do, try and strengthen it. If we'll make reasonable efforts to publish the book within 12 months, see if you can get it to be commercially reasonable. It's one step up, and it gives them a little bit more pressure to get it done. It's not just a random person off the street, it's other people in this industry. Similarly, adding good faith before efforts can be a useful thing. Similarly with like discretion. Good faith discretion is a good way to make sure that the publisher, in its sole discretion, doesn't get to decide one day that they, hate books about penguins and therefore aren't going to publish your book. They're using good faith efforts. Books about penguins or good faith discretion. Books about penguins aren't selling well anymore and they don't want to do it. That's good faith. Bad faith is lots of other things. There are other things like state of mind, right? So knowingly versus recklessly versus negligently, right? So if you knowingly do something, it's you absolutely know you're doing it with intent, you know what the repercussions are. Recklessly is you don't care what the repercussions are. Negligently is you didn't take enough care. And then there's no state of mind, right? So if the author knowingly doesn't turn in a book, then you knew what you were doing. If you negligently didn't or recklessly didn't turn in a book, you held it in a single hard drive that was encased in glass, and then you brought it scuba diving. Probably wasn't the best idea to do that, and you were pretty reckless about it, right? So that can be something that also softens or strengthens things. Similarly, may or can are very different from will and shall. Will and shall are definites, may and can are a little more wiggle room. Try and get things like mutuality. Are you agreeing to something that the publisher should too, right? Are there representations they can make? And that's something that, for example, if you're working with a publisher on a picture book and you're the author and they're going to bring in an illustrator, maybe you can get them to make a representation that the illustrator will have all the rights they need to have. They'll have their own contract with the illustrator. But if you can get that, then if the illustrator messes up, you're protected by the publisher, right? Is there something that you can get them to promise and then indemnify you against? Is there anything like, back matter or cover art, right? In the area of AI that might be useful. It's not always easy to get it, but it's something to consider asking for if there's something obvious. And then the other thing that you want to watch out for are waivers of rights. So for example, equitable remedies. This is a very legalistic term. Effectively, when you go to court, there are two types of things that you can do: a case at law, a case at equity. Law just means money. I don't know why we don't just say a case for money, but it's a case for money. Whereas an equitable remedy is something different that is more active. So for example, what's called like a preliminary injunction or a restraining order is an equitable remedy. So are you waiving the right to put out a restraining order if they do something bad with your book? Usually, yes. And that's usually not necessarily a bad thing, but just know that you're doing it because it stops you from being able to do anything. There are other times where there are waivers of actions at law, meaning for money. That should never be the case, in my opinion, because you should always be able to sue them for money. What if they don't pay you? You should absolutely be allowed to sue them for money. Same thing with damage caps. There are some times where they say you can only get money up to the amount of the advance. Well, does that make sense? Shouldn't you be able to get whatever money they've made off of you? You know, with taking into account the advance maybe, but I'm not sure there should be a cap. If there is, there's got to be a good reason. And similarly, waiving a jury trial or agreeing to arbitration. None of those are inherently bad. It's just important to understand what you can and cannot do. And that's kind of the takeaway that I have, is understanding your rights and knowing what you're giving up and what you're not. That is my presentation for the moment, but I know that I see lots of questions, and I know that there were lots that came in, so I want to turn it back to Tamara.
Thank you so much, Rebecca, for this hugely informative contract survey. We do have questions. I'm going to start with the pre-submitted ones, and then we can move on, if we have time, to some of the open questions that are still in the Q&A. So to begin, can you talk a little bit about the differences in contracts depending upon genre that we should be careful to recognize? For example, a cookbook contract versus a picture book contract, things like that.
Absolutely. So nonfiction versus fiction to begin with. In nonfiction contracts, you're going to look for a lot more of those data verification provisions, right? How much data verification do you need to do? What sort of follow-up? What sort of additions are allowed to be made after the fact, right? A lot of nonfiction or academic books need to be updated as things change and go forward. That's not really going to be something that needs to happen for fiction. Similarly, like a cookbook, it's going to be really relevant to make sure that your in representation that if recipes are followed correctly, they're not dangerous, is true, because people are actually going to be following recipes. Most of the time in fiction, there's not really a recipe to follow, right? If there is, equally important. For picture book contracts, I've mentioned a couple things already, such as what edits the publisher is able to make. That's where like rhyme scheme might be something that comes into play. And I know that there has been a lot of discussion and seminar about this already, but I think AI is especially important for picture books because oftentimes art is involved. So if you're an author illustrator, making sure that like you have really strong protections there, because I think we have a lot more understanding of the damage that AI can do in the art space, more so at the moment than we do in the book space, though I'm sure it is equally concerning all around. I would say that in all categories, understanding what your genre and age range are is important for like your competing works, right? And your option, because the narrower you can get it, the more flexibility you have going forward. So if your option is for your next adult book, well, your next adult book has to go to these guys before anyone else can look at it. But if it's your next adult book of fiction, that's more narrow. Your next adult book of fantasy is even more narrow, right? Grounded fantasy, even more narrow, right? So understanding where you fall and what you want to do will give you the most flexibility there.
Thank you. I'll also add really quickly for if you're an author and there's an illustrator that you haven't chosen yet to be brought onto the project, negotiating for author approval over the illustrator or meaningful consultation is something to think about for authors who are not also illustrating their books.
I will also add then in that case also same with audiobook narrators. If you have a book that is likely to become an audiobook, you are not likely to be able to choose the narrator unless you have a lot of sway, but often consultation or meaningful consultation is something pretty achievable because you can at least see who they're thinking about.
Moving on to our next question. So I think we've covered this, but can you negotiate for what you want? Which is a very straightforward question, like book cover art or title or interior book design.
You can negotiate for anything ever. You might not get it, but you can always try. I would say that I have seen a lot of this in picture books, especially basically a list of things that you can consult or approve on, right? Approval means you have a yes or no vote. Consultation means they'll talk to you first, but it's their decision. Meaningful consultation is they'll really take your thoughts into account, but it's still their decision, right? Sort of the spectrum there. There's a list of things that kind of go into that, right? Like narrators, cover art, interior design, pagination, cover and flap copy, right? Like the blurbs that are on the front and the back. There's a whole lot of these. Especially like condensations, abridgments, all of those things, anything where they're taking your book and making it shorter or longer, including it in an omnibus edition, the inclusion of advertisements. Those are all things that you can reasonably try to get approvals over or consultations over. I would say other things that are less negotiable are things like the lawyers are going to read it. They're always going to read it. You don't have a choice in the matter over that. Also, most publishers are not going to give you, again, unless you have a lot of sway, the right to approve or disapprove of any subsidiary contracts. Subsidiary meaning this is not a thing they're doing themselves. If they want to make their own audio edition, they'll do that, but oftentimes they'll subcontract. They'll give a new contract with a different license just for the audio rights to your book to an audio publisher. Usually you don't have the right to up or down vote that. That's going to happen, and the most you can do is see the terms after the fact. And unfortunately, that's kind of just the way that it is. But in my opinion, you can always ask. And my rule of thumb is that if you ask a question in good faith, you should never get a bad faith response, right? Anyone who is interested in working with you should be able to answer your question. They may not agree, but they should never be offended that you are asking it.
I 100% agree with that. Yes. About the if they're offended that you asked, it's not a good sign about that publisher.
Yeah.
So our next question is a little more specific. Are contractual terms ever up for renegotiation after a book's success? Can clauses be added to allow for flexibility?
Let me answer the second question first because it's easier. There are some things that allow for flexibility. There is a clause that I have seen in a number of contracts now, particularly Big Five contracts, that say, if our terms on, if our royalty rate for this particular right becomes better, right, like as a general rule, right, if the royalty goes from a base of 8 to a base of 9%, then that will be applied to your contract. Meaning, if your book is successful 30 years from now, right, or even 10 years, and audio rights are no longer sort of standardly 25%, they're more like 40%, that will retroactively be applied, or not retroactively, that will be applied to your contract going forward once it is deemed to be the standard. Standard meaning it's not sort of a one-off exception for like a fancy author, right? It's sort of anyone who comes in off the street and gets a book published will get this 40%. I'm making that number up. That's not a real thing. But that's something that absolutely I have seen added in for further flexibility. There are also, like I said, reversions, which are ways to sort of make sure that if nothing happens and they just sit on rights for a while, you get them back. And then you can do whatever you want with them, right? And that's a useful way to move forward. There are also ways to sort of amend contracts later down the line where, for example, if you make it really big and they want to put out an edition that like in a format that didn't exist before, or in a way like a really special edition, there might be a supplement added being like, hey, you hit it real big and we really want to take advantage of that, do a really big reprint of this, and we're going to give you a better royalty rate because of how big a deal you are. I would say that for the most part, once you agree to terms, you've agreed to terms. And there's not really a way to renegotiate, unfortunately. I won't say it never happens, because I think once you hit it big or once you're a massive success, then they are inclined to want to keep you happy. but I also wouldn't get my hopes up. More likely, you're stuck with what you got for that book, and your next book's going to get a really good set of terms. And that's kind of, unfortunately, the reality of it. But I also haven't had a book hit it big yet, so I'm happy to defer to Tamara if that is not your experience.
I would just add and say that sometimes you can negotiate a refresher advance. So you mentioned perhaps like better royalty terms if the sales are great. Sometimes a refresher advance, which means you know, in addition to the advance that's already been paid, they'll like add a sort of, you know, lump sum of money that's an additional advance against future royalties. And then it's up to you and your agent to figure out if that math makes sense, because, you know, if you're getting like, I don't know, 100K in royalties every year, does it make sense to get 100K advance already, or does it make sense to go more, or, you know, just a calculation to make. But refresher advance can happen, but it is if the book has to be like really big.
Yeah, I will add, I guess, on top of that, 2 other things. First, your option book, a way to make sure you can sort of capitalize on any success is to make sure that the option clause, meaning like their right to review your next book, doesn't lock you into the same terms as this book, right? A lot of times the clauses will say, you know, if we like your next book, we'll give you a contract on these exact terms, meaning the same advance, the same royalties. If you want to leave the flexibility, like, it's a little risky just because, like, who knows, that may have been a really good deal. But also, if you hit it big, then you don't want to be locked into the same terms that you agreed to when you were nobody, right? So keep getting rid of that kind of language. And then finally, bonuses are something like, if there's a book where you're like, I know this is going to be the next big thing, or I'm pretty sure this is going to win some sort of award, there are ways to get bonuses added into the contract, usually as an advance for like hitting the top of the New York Times bestseller list, winning a Newbery medal, you know, hitting a certain, earning out your advance within X number of months. And that's not really a renegotiation. It's just a nice additional sum of money that you might get in the event that like things go really well.
Thank you. So the last of our pre-registered question is about definitions. So we got a few questions about certain legalese terms. Can you tell us what right of first refusal means?
Yeah, and I've mentioned it a few times, so I'm definitely glad to have a chance to like go into it for a sec. Right of first refusal is often similar to an option, but it is not necessarily. But basically, a right of first refusal means the publisher is not buying the thing now, but they may want to later. And so basically what that means is, like, for example, if you don't give them audio rights, right? You keep them for yourself, but some later date you intend to sell them. If they ask for a right of first refusal, it means once you get an offer, right, for that those audio rights, you go to them and say, we have this offer, you gonna match it? And then they have the chance to match it. That's one way it can come up. The other way it can come up is in an option, right? An option just means they have the option to buy the book before anyone else, which is often a right of first refusal, where they have the chance, right? Once your book is published, most of the time if it's a picture book, it's probably the book. If it's a novel, it's usually it's often a synopsis in 3 chapters. They get to look at that and go, do we want to publish this next book based on how this book is doing? They have a certain amount of time, usually 3 months, to review it, make an offer. If you like the offer, then you negotiate with them. If you don't like the offer, then you say goodbye and sell it elsewhere. But it is their right to refuse that book before you send it anywhere else. And that's what right of first refusal means, is they have the right to turn it down before you go somewhere else to sell it.
Thank you. Another definition, a question about a definition that came in. Can you explain moral rights?
Yes, kind of. Moral rights are really big in Europe for the most part. Moral rights are not formally adopted or not really, it's hard to say. Moral rights basically means It is a right of the author to be recognized as the author of the work, right? It is adjacent to copyright, but it is not the same as copyright, because copyright is a legal right. Moral rights are more amorphous, right? It's kind of more of, in legal terms, common law, right? As opposed to written law. And moral rights are not something that ever have to be registered. They're not something that ever have to be formalized. They attach as soon as you do it. So the two major moral rights are the right of attribution and the right of integrity, right? The right to make sure that the author is always named, and the right to make sure that any action that would destroy the integrity of the work has to go through the author themselves. Effectively, this is yours and no one can take that away from you. In Europe, these are much more emphasized. In the US, kind of those things are already encompassed under our copyright statutes and common law, and actually it's in the Constitution. In Europe, you're going to see moral rights emphasized a whole lot more. And for the most part, you hope they never come up, but it is a way to make sure that you keep your work in the form and fashion that you want it.
Thank you. So I think we might have time for one more question. Johnny, what do you think?
Yeah, certainly.
Um,
I'm good to keep going.
okay, I'm mindful of the time, but something in the Q&A that came up is, can you speak about morality clauses?
Yes, I briefly had them in there and then I just glossed right over it. A morality clause about 5 years ago was like the issue. Now it's AI, but that's because we've largely kind of settled into a pattern that we're comfortable with. A morality clause is a publisher invention that is used to basically give them an out if something happens online that they don't like. In most cases, a morality clause states, if the author does something that we consider terrible, we get to terminate the agreement. That was the original form. It used to be like if there's widespread public condemnation, which like for authors of color or queer authors, like that is not helpful because the internet can turn against someone for literally no reason. And so about 5 years ago, there was a really big push. I mean, it's still happening, but especially 5 years ago, to narrow that. So where I've kind of seen it land is acts by the author that are materially inconsistent with their reputation at the time of signing. That's the good version of it, right? Because that means if you are known as a lefty queer advocate when the book was published, no one can be surprised that you're still doing that after the book was published. And if the internet turns against you for that, that's not helpful. If you're a librarian who wants people to read books before the book is signed or published and after, no one can be surprised if you're still a librarian who wants books to be published, no matter how controversial and silly that might be, right? So your morality clause in general should try and be confined to that kind of language, if that's possible, and also confined to things that will actually hurt sales of the book and not just things the publisher decides one day are not cool. They can be useful. There are situations like what recently happened in the Goodreads scandal and all, where a morality clause may actually be useful and productive. I don't actually know if it was used, so that's just pure conjecture on my part. But also there are plenty of times where I'm sure it's overused. So getting it to be as narrow as possible is going to be your best bet.
Thank you so much, Rebecca.
You're muted.
Any thoughts on AI? I know the Authors Guild is working on tweaking language for an AI clause. If you
Right
don't want
now,
your work to use.
It is the right thing to do, and it is so far pretty fruitless from the agent side. I have noticed a couple of things. In general, it is doable to get publishers to agree to put language in saying no AI art, no AI cover, and no AI narrator. Those are 3 things that I have seen, not always, but pretty reliably are something that I can get publishers to agree to. I have basically had no luck, and I think that's relatively true for most of my colleagues, in getting any sort of promise not to use AI or not to use generative AI training, right? Not to feed this book into a generative AI machine, not to do anything like that. Unfortunately, I am now seeing the opposite side. Now, I don't think any of my authors or Bradford's authors are going to use AI to write their books, but I have certainly been seeing clauses being added saying, oh, the author can't use any of these materials, and you're going to represent and warranty that you're not using AI to write your book. We're not going to promise anything, but you have to promise, which I have thoughts on. But it is something that some agents are treating as a subsidiary right, the right to use these to train or to adapt for generative AI or machine learning, I think is now what it's being called. I have seen others who are trying to get as much in there as possible. I do as much as I can for very specific things added to the books that might hurt the authors and illustrators. And unfortunately, most publishers are saying these days, look, we don't know what's going to happen. We can't make any promises. And that's not how contracts work. Contracts are promises. That's exactly what we're doing here. I don't see why we can't make promises.
Right.
I know that's not helpful, sorry.
No, that's great. And yeah, I mean, we're announcing new things all the time. We have a whole dedicated page to AI advocacy, so expect updates there from us. If I can just ask one more thing, do you have any advice for like maybe a clause that should be in there, language that should be in there in case your publisher is acquired, merges with another publisher? A lot of small presses get acquired.
Yeah, so there's two sort of scenarios there, and this is something that I've certainly been adding into a lot of contracts. One is for bankruptcy, and one is for acquisitions. Most publishing contracts don't allow authors to assign their obligations or rights, right? Which means that you can't just pass it off to somebody else. However, most publishing contracts do permit the publisher to do it so long as it's part of like a full transfer, right? Like a company buyout. If you're concerned about that, I would suggest either one of two things: having a general right of termination, right? Either party can terminate this after X number of years upon 30 days notice. For most publishing contracts, you're not likely to get that because you also don't want them terminating the contract for no reason. But there is certainly a way to get a termination provision put in saying, in the event of a full corporate buyout, right? The author shall have the right upon 30 days notice after after being notified of such buyout to terminate the contract without further obligation. And that's a way to sort of protect yourself. There's not really a way you can't stop it from happening, right? So that's one way. The other thing is for bankruptcy clauses, I have basically been asking everyone to put in there, if the company goes into bankruptcy or has no assets or is unable to fulfill its obligations like payment, the contract terminates immediately and author gets to keep all money paid to them so far. Unfortunately, in bankruptcy, you can't really get more money out of them for the most part. You're pretty low on the list of priorities, but at least your rights are back with you and not caught up in a bankruptcy court.
Gotcha. All right. Well, this has been great. Rebecca Maddie of Bradford Literary Agency, Tamara Kawar of DeFiore. And Rebecca, I believe you're closed to queries right now, but hey, you're the contracts manager at Bradford, so check out Bradford Literary.
Well, I'm closed to queries only until May 1st, and then I will be open again. I do adult and YA, sci-fi, fantasy, and romance.
Wonderful. We got a lot of kudos in the Q&A box from new and veteran authors some of whom have been doing this for decades, and they learned things and gained clarity. So thank you from all of us, and thanks to the audience for being here. Thanks for being so engaged. We love doing this. Feel free to get in touch with me at support@authorsguild.org for stuff about our educational programming, or staff@authorsguild.org if you have questions about the Authors Guild and what we do. Thanks to AALA and Literary Agents of Change.
Thank you. Thank you for having me.